Global happenings today. We communicate. We analyze global news. Stay tuned.
Hello guys, welcome back to our channel. The unconstitutional move by President Bola Ahmed Tinubu to suspend an elected governor, precisely Siminalayi Fubara, from his position as the governor of Rivers State and bring in a sole administrator has been resisted by some very strong lawyers, and they have dragged him before the court. You are going to hear full details of the suit, which will kickstart at a particular date. In the news, I'm going to give you full details of that. This is a very strong move towards restoring back the beauty of democracy. And if everything is done the way it should be done, I think that once again, Siminalayi Fubara will be brought back to his position. But however, I wouldn't like to preempt. Let's listen to the full details of the suit as Bola Ahmed Tinubu, alongside the sole administrator with other persons, have been dragged before Federal High Court. According to the news, the Federal High Court sitting in Abuja has fixed April 10 to hear the suit that is seeking to sack the sole administrator of Rivers State, Vice Admiral IbokEtte Tenure, as retired. The suit, which has President Bola Ahmed Tinubu as first defendant, has been assigned to Justice James Omotosho for hearing, and the Attorney General of the Federation, Vice Admiral IbokEtte, retired, as well as Attorney General of the 36 states of the Federation, were listed as second to 39 defendants in the suit marked FHC/ABJ/CS/572/2025. The legal action was instituted by an Abuja-based legal practitioner, Mr. John Mary Jide Obi, who is praying the court to set aside as void all actions and decisions, howsoever described or made, of the third Vice Admiral Ibas, retired, in the name of sole administrator of Rivers State, same being unconstitutional, null, and of no constitutional force throughout the Federal Republic of Nigeria for all purposes. The plaintiff is further praying the court to issue a perpetual order of injunction restraining the first defendant, Tinubu, either by himself, his officers, agent, privy, servants, or any other person acting under his command, howsoever named, from either removing, suspending, or otherwise tampering with the tenure of the governor and deputy governor of Rivers State, and indeed any other state in Nigeria. Likewise, an order of perpetual injunction barring President Bola Ahmed Tinubu, either by himself, his officers, agent, privy, servants, or any other person acting under his command, howsoever named, from appointing any sole administrator into the state government house in the 36 states of the Federation for any purpose whatsoever. In the originating summon he filed through a consortium of lawyers led by Mr. Chimeze Enuka, the plaintiff urged the court to determine whether, in view of the combined provision of the entirety of Section 15 subsection 180, Section 188, Section 189, Section 305, and 306 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and their conflated interpretation, the President of the Federal Republic of Nigeria, first defendant herein, has any constitutional authority whatsoever to either remove, suspend, or otherwise tamper with the tenure of a duly elected governor and deputy governor of Rivers State, and indeed of any other state in Nigeria, and appoint a sole administrator or any other substitute, howsoever called or described, such as the third defendants for that state. Upon the determination of the question, he the court to declare that upon an intimate reading and complete understanding of the entirety of Section 305 of the 1999 Constitution as amended, there is no other circumstance contemplated by the Constitution for the removal or interruption of the tenure of an elected governor and deputy governor of the state, except the circumstances contemplated under Section 180, Section 188, Section 189, and 306 of the 1999 Constitution of the Federal Republic of Nigeria as amended. A declaration of this Honorable Court that in view of the entirety of Section 1, subsection 5, subsection 280, Section 188, Section 189, Section 305, and Section 309 of the 1999 Constitution of the Federal Republic of Nigeria as amended, the President of the Federal Republic of Nigeria has no constitutional authority to either remove, suspend, or otherwise tamper with the tenure of a duly elected governor and deputy governor of a state and appoint a sole administrator for or any other substitute howsoever called or described, such as the state defendants herein in that state. A declaration of Honorable Court that the purported suspension of the governor and deputy governor of Rivers State of Nigeria by the first defendant on Tuesday, the 18th day of March 2025, is unconstitutional, null and void, and of no legal effect whatsoever. A declaration of the Honorable Court that the purported nominations to appointment and swearing in of Vice Admiral IbokEtte Tenure, retired by the first defendant as the sole administrator of Rivers State of Nigeria, is unconstitutional, null and void, and of no legal effect whatsoever. An order of this Honorable Court setting aside the suspension of the governor and the deputy governor of Rivers State of Nigeria by the first defendant on Tuesday, the 18th day of March 2025, for being unconstitutional, null and void, and of no legal effect whatsoever. An order of this Honorable Court setting aside the nominations to appointment and swearing in of Vice Admiral IbokEtte Tenure, retired as the sole administrator of the Rivers State of Nigeria by the first defendant, as well as an order of this Honorable Court directing Vice Admiral IbokEtte Tenure, retired, the third defendant herein, to vacate forthwith the government house of Rivers State of Nigeria. In a 32-page affidavit he deposed in support of the suit, the plaintiff maintained that though President Tinubu has the constitutional power to declare a state of emergency in deserving circumstances in any part of the Federation, he does not have the power to suspend elected official like a governor or governor who is not his appointee. As a Nigerian lawyer and all through my years of practice, I have never seen the word sole administrator in the amended 1999 Constitution of the Federal Republic of Nigeria. I know that neither the first defendant nor the second defendant appointed the governor and deputy governor of Rivers State of Nigeria, and that no governor or deputy governor in Nigeria is an appointee of the first and second defendants. I know that Nigeria practices federalism hinged on separation of power. I have instituted this suit in the public interest, in the defense of the rule of law and accentuation of the supremacy of the Constitution, and to preserve the integrity of the Nigerian Constitution, which is the most sacred document that holds Nigerian state in balance and in being. I am genuinely worried that in the absence of the intervention of this court, removal of duly elected governors and deputy governors may become the pastime of the president, thereby opening the floodgate of anarchy capable of consuming this nation. It will be in the interest of justice for this honorable court to grant the prayers contained on the face of this originating summon. Wow, that was a big one coming in there, and I think this has captured all the worries of Nigerians. I must say, this particular suit has captured all the worries of Nigeria. And I believe that if the lawyers or the judiciary would do what they should do, especially in the area of interpretation of Section 305 of the 1999 Constitution as amended, it will terminate this whole bwahaha we are seeing in Rivers State, this unconstitutional move of the president, and will, for at least until time, control the domineering attitude of an elected president against an elected governor. There is no provision in the Constitution of Nigeria that recognizes such. So this move by this particular lawyer, if it is treated with the integrity of the court, will kind of salvage the situation in Rivers State and restore back democracy as the people are expecting. That's what we'd like to leave it. Let's meet in our conversation.